Hi everyone. This is part 2 of the seminar in relation to trust of land, and I'm going to talk about express trust. In the previous video I talked about express trust when two persons buy land. They could be married, they could be unmarried, they could be commercial partners, they could be friends. When two persons basically buy land and they fail to express the nature and the extent of their beneficial interest. Equity follows the law, and there's a presumption that they do hold the land jointly in law as well as in equity for themselves and on behalf of each other. What that means that they hold the land on a 50-50% basis, and also the nature is a joint tenancy, which means each upon the death of each other is going to inherit his share of the land. However, if there's a tenancy in common, nobody upon the death of each tenant, he can predetermine who he's going to pass his share to. Now, it's extremely important to understand understand why you should draft a good trust deed, and you should get advice from an experienced land law attorney in England and Wales, who basically knows the technicalities and the aspects of the law, so that you're safeguarded. So in case a relationship breaks down, you're not running in the at the last minute to safeguard what you really think it's yours, and you're not exposed to a court ruling that is going to rule what you have and what share you have, and what the nature of your share is according to its own basis, its own objective basis. Now, it needs to be also understood, moreover, the importance of an express declaration, however, has its stamps as well. It must be honored, unless there is it can be amended by later agreement, which means, understandably, that you are going to have to seek the consent of that other co-owner, and especially that's very hard when your relationship is on the rocks and you have only fallen out, and also it can maybe by proprietary estoppel. It also may be set aside if there is a vitiating factor improved, which means there's undue influence on one of the mind of the partners, there's fraud, or there is mistake, or anything else. However, it is very hard to detract from that. It's conclusive evidence. This is very hard. So it's extremely important that you understand the consequences of having expressed trust there. No matter if there is a reason or a nominal reason that, let's say, for example, that one of the partners was joint mortgagee, and the real reason that they are both on the mortgage and they both co-owning the land is for one person to be able to buy the house and to be granted a loan by the bank in the first place. That's the real reason that they appear on the land, on the conveyancing documents together. If that's the real reason, if there's an express trust, it's hard to detract from that. Now, on a final note, if there is a tenancy in common, let's say, and the shares are not specified, well, assumingly, this is conclusive evidence against any other extent that's contrary to a 50-50% share, because no constructive trust or no other implied trust or resulting trust may be admitted as evidence against the expressed trust. It is conclusive evidence, and only if there's a mistake per se or some kind of vitiating factor with regards to that declaration that there's a tenancy in common. Remember, no extent of share has been mentioned. This is good. Well, I mean, the parties are going to be held according to the latest presence of the law of England and Wales to be holding the land on a 50-50% basis, but they are still going to be holding the land as tenants in common. Express trust. There are basically forms from the Her Majesty's Land Registry, and also express that they can be filled whatever time after the purchase by co-owners, or they can also arise when there's an express trust from a grantor. That means a settler. That means a person basically passes land to more than one, and the trust document basically explains expressly and declares expressly what is in there. Well, everything else that needs to be interpreted may be interpreted according to the law of interpretation of trust. it's very important. You're buying property. Don't waste the chance. Don't miss the chance to predetermine what you will, what you own in that property together with the other co-owner, no matter what the status of your relationship with the other co-owner is. Married partners may have some limited protection according to some family law status, but then again, it's always better because the substantive rights of the parties with regards to property, whatever the status, are always, most of the times, they're almost resolved according to substantive land law principles. Thanks very much. The choice is yours to explicitly declare the beneficial ownership of the property that you're buying together or not. See you in my next video. Bye.